Thank you all for joining. Today we will be reviewing the case of North Broward Hospital District versus Catalan, a case that discusses non-economical damage caps, equal protection, and medical malpractice reform. I'd like to start by creating the bigger picture, a case overview. It all started in 2007 when patient Susan Catalan approached the hospital complaining of having a carpal tunnel surgery performed and walking out permanently in conditions of an injury that were caused by medical negligence. She was awarded by the jury verdict 4.7 million, including 4 million in non-economic damage for her pain, suffering, and loss of quality of life. However, the non-economic award was reduced by nearly half by Florida Statute 766.118. The issue of litigation came down to this. Is the statutory limitation an infringement of the Equal Protection Clause of the Florida Constitution? The Florida Supreme Court answered yes in 2017. I would like to walk us through the scenario of what really took place. Kylie was having a regular outpatient surgery that normally generally undergoes general anesthesia. During the intubation process, the tube pierced her esophagus. The anesthesiologist, who did not know the perforation occurred, gave her pain medication, did not do an internal check, and sent her home that same afternoon. The following morning, her neighbor found Catalan in an unconscious state in her home and immediately took her to the emergency room. She had to undergo emergency surgeries to fix her esophagus, was kept in a medical induced coma for several weeks, had to undergo several more surgeries, and was forced to learn how to eat and move again. She also testified to constant pain in the upper half of her body and her back, and several mental effects, both due to the trauma and the loss of agency. Her injuries were classified by the jury as catastrophic. The case was carried through all the tiers of the court system. On the trial court level, the statutory caps were used by the judge, who decided to lower the amount of the non economic award to just about $2 million, whose portions of the award also had the limit of $100,000 because it was a state hospital. Catalan appealed, and the Fourth District Court of Appeal ruled in her favor based on the McCall decision back in 2014, which led to invalidated similar caps into wrongful deaths packages. The Fourth District instructed that in the reinstatement of the entire jury award should occur. The hospital district took the case all the way to the Florida Supreme Court, which affirmed that the Fourth District in a per curiam decision. The caps were not constitutional, both when it comes to the wrongful death and personal injury. So the judicial review that applies is the lowest effort of the judicial effort. The review basics test, which was applied as no fundamental right or the protected group was involved. With this test, a statute must merely be conceivably connected with a valid government purpose to survive. The Florida statute FL 766.118 establishes fixed ceiling caps of non economic damages depending on the type of injury. Despite this being the lowest standard of judicial review, the Florida Supreme Court concluded that the caps failed on both counts. They produce arbitrary differences in classes of injuries, and there was no proven linkage between the caps and malpractice insurance premiums reduced or the healthcare access. The rationale of the 2003 legislative crisis was not backed by any existing data. To explain the case of equal protection down to earth, in an example which the court itself has used in this case. Suppose that there are three plaintiffs who were injured by the same defendant. Plaintiff A has a moderate injury. His or her jury award does not exceed the cap, and therefore he or she is compensated 100%. Plaintiff B loses a hand, a catastrophic injury according to the statute, so their settlement can be limited to $1 million. And then there's Plaintiff C remains in a permanent vegetative state, which is argumentatively a much more devastating result. but is subjected to the same cap of $1 million as plaintiff B. The tortifer that causes most damages contributes to the least according to the actual damages done. The court was right in its decision, and this scheme of arbitrary, irrational, and is completely unconstitutional. Catalan, you must know its predecessor. The Florida Supreme Court ruled on a state of McCall versus in 2014, the United States, that invalidating that non-economic damage limits in medical malpractice, wrongful death cases in particular ways. The caps were arbitrary in that they were found to disadvantage those families that had multiple victims in it. Basically, the people were affected by the loss of the loved ones, the lesser they could recover. Catalan appealed that the Constitution reasoning to the living plaintiffs and personal injury cases. When combined, the two decisions abolish non economic damage limitations in all medical malpractice law in Florida. This is a substantial change in the legal environment of healthcare providers and insurers in Florida, and is now an entire uncapped jurisdiction in this area. What is the actual implications of Catalan to hospitals, physicians, and healthcare administrators? First, it subjects the provider to entirely open jury awards. A patient who is hopelessly damaged is not able to reclaim the full sum decided by a jury with no legal limitations. This possesses actual financial risk, especially in specialties with high risk, such as surgery and anesthesia. In turn, malpractice premiums have increased. Nevertheless, the court decision gives a clear message to the market as well. The cost of negligence is total. This ought to has an investment in patient safety infrastructure, simulation training, error reporting systems, and quality improvement programs. Jennings helps to remember that ethical risk management is not only an ethical duty, but is also good business. Companies that avoid harm gets less claims and reduce overall costs in the long term. My conclusion is in favor of the court as well. These caps were not evidence based. They were convenience based on the legislative side. Patients with serious injuries, such as Susan Catalan, need to be properly compensated in any possible way and not have haircut randomly on their pain in order to experimentalize on insurance. In the future, my two suggestions are to adopt the following policies. To start with Florida. Florida legislature must seek communication and a solution programs and apologize laws that are constitutional alternatives to caps. Such programs have proven to be successfully in other states. They will decrease legislation, enhance transparency, and not to violate victims' rights. Second, healthcare organizations are supposed to put a lot of investments on proactively adding safety systems. It is also extremely convenient, and we've seen the data time and time again that adding and including prevention programs generate long-term lasting premiums reliefs compared to tort restrictions. This is no conflict between accountability and quality care that go hand in hand. There are six takeaways from this case. The first will be that they'll never pass an equal protection review of systematically under compensating statutory cap of damages on the most severely injured. Second, the even softened rational basis test has found when the justifications of a law runs out, with the flow of time conditions change and the court will feel it. Third, healthcare administrators and business leaders must realize that tort reform is not the alternative to the real risk management. This has resulted in the lack of statutory ceiling, so the negligence has a full financial implication. It will put organizations in a better legal, financial, and ethical position than those that use caps as a safety net due to their investment in safety culture, training, and disclose programs. Time and for joining me in reviewing this case.